Good afternoon. My name is Lauren Eisen. I'm an attorney licensed in New York and New Jersey. I focus in special needs, guardianship, trust and estates, and also elder law. And I am going to talk to you today, just generally, about some concepts for special needs planning with your family. So this involves your loved one, your child who's special needs, also your planning, and then also your whole family. It's really important to consider everybody. So what are the things you need to start to think about with your child? So when your child is small, most of your interactions are with the school, and you get a lot of great benefits from the school system. Then as they start to get older, you have to start to think about some things. So right about when they're getting to be 18 is when you have to start thinking about kind of the next phase of what you're going to need to do. Because believe it or not, when your child turns 18, they are considered an adult. And so when that happens, things can change. For example, now they can be responsible if they make a contract, if they do certain things. If they sign a contract for a Tesla, they are now legally responsible because they are considered an adult under the eyes of the law. Same with health decisions. Once they're over 18, they can make their own health decisions, decide what type of medications to take, what kind of doctors to see, and it's really up to them because they are now an adult under the eyes of the law. So there are different options depending on your child's need. One thing to think about is guardianship. Is guardianship something that might be appropriate for your child? So in New York, and most of what I'm going to talk about, I am licensed in New York and New Jersey. I have clients all over the New York and New Jersey area. This is going to be geared towards New York, but most of the concepts also are viable in New Jersey as well. So in New York, there's a special type of proceeding for a guardianship just for this type of situation where a parent is going to become the legal guardian of your child. So again, a lot of people are going to think, why do I need to even think about this? My child's turning 18. Nothing's really changing. He's still living in my house. He's going to school. I'm feeding and clothing him. That's true, but now that person is an adult. So if you think going on after they're 18 and forward, they're still really going to need you to play the same role as a guardian to help them and manage their finances in case they were going to get taken advantage of. Also to help them with the daily activities of just getting through the day, talking to doctors, all those sorts of things. If you think that they might need ongoing help with that, that's when you start thinking about becoming their legal guardian. And in New York, that's called the 17A guardianship. And it's very much driven by diagnosis. So the way the statute is written, it has to do with whether the child is developmentally delayed or intellectually delayed. So a big part of the guardianship deals with the two affidavits that doctors do. One is submitted by a licensed physician and the other can be a therapist. So when we petition the court for a parent to become a guardian, the court relies very heavily on the doctor's affidavits. Now, doctors can be, I'm married to a doctor, so I'm not saying anything negative about doctors, but sometimes getting doctors on the phone, getting them to focus on the affidavits, getting them to write legibly and to explain the situation can take some time. So when families are looking at guardianship, I always say it's good to start when their child's about 17, so we can kind of get everything ready and then all our ducks in a row, and then we submit that to the court. So the court, we submit a petition that the mom or dad is going to petition to be the guardian, and we also submit the two doctors' affidavits, and the court appoints a guardian ad litem, which is another attorney who basically reviews the file, will interview the parents and the child, and then they will make a recommendation and a report to the court. And the court relies very heavily on that report. And usually there are no issues. It goes very easily. There is a hearing at the end. Very quick, as long as all the parties agree, and it's a fairly easy process as legal processes go in New York. It's not done in the big, fancy Supreme Court in New York. It's done in the smaller, easier to navigate surrogates court. And that's kind of how guardianship works in New York. Now, how do you decide if guardianship is even appropriate? It's a hard decision, and really, I tell families when you're starting to look into this, talk to the teachers. Talk to the doctors who would be making the affidavits. They really know your child, and they also know the guardianship process. So that's usually a really good place to start. Now, guardianship is great because it will help you protect your child, because once you become the guardian, you're in charge of their finances. They can't They can't make that contract for a Tesla that you are the one who would be dealing with all their finances. Same with medical decisions, taking medications, talking to the doctors. All of that is maintained, and it makes it very easy for the family. What if your child really doesn't need a guardian? So, special needs is a very large term, and there's a lot of variations in that term. And so there are definitely some special needs children who don't need a guardian. They can do most things on their own. They need some help, but they pretty much can handle things. So what do we do for them? You still want to make sure you have some planning in place for your child. And what that planning would be is when they turn 18, if we're not going down the road of guardianship, then I always urge my families that the child, once they turn 18, should sign a power of attorney. Power of attorney is a legal document that says whoever I appoint as my agent can do all financial things for me. So the child would appoint the parent as the power of attorney agent so they can be on all their bank accounts, they can watch everything, they can talk to Social Security, they can do whatever is needed financially. And then there's the health component. If we're not doing guardianship, when a child turns 18, and this is for any kid, kids going off to college who are leaving, it's really a good idea to have this done, sign a healthcare proxy. The healthcare proxy, the document the child would sign, naming their parent as an agent to make healthcare decisions for them. But unlike guardian, if you do a healthcare proxy or power of attorney, later on your child can always revoke it. Your child can always say to the doctor, yes, she's my agent under my power of attorney if something happens to me and I can't talk to you, but you know what? Otherwise, don't tell my mom anything. I don't want her to know. So it does help because it put things in place, but it's not as much of a control as guardianship. It doesn't mean guardianship is always right. It really depends on the family dynamics and the child and what they need at the time. So aside from guardianship and also proper documents for your child, another part of your child's planning as he or she gets older is SSI, Social Security income. Anyone between 18 and 65 can apply for Social Security income. And what that is for people who have a severe impairment so that they can't work to support themselves. And that means it's a supplement, and it's based on, it's means tested, meaning only people have very limited assets and income can receive Social Security income, and they also need to prove that they can't work, that they do have a severe impairment. So it's not a lot of money. In New York, they bump it up a little from the federal. It's about $800 a month, but it's a great stipend for someone who either can't work at all, or you can have a limited amount of work. You can have about $1,600 a month in income. So your child could be, I have a lot of families where the kids work at grocery stores, and as long as it's under $1,600, that's okay. And then the resource limit for Social Security income, they can only have $2,000 of assets in their name. That is not a lot. But I'm going to tell you ways that you can keep money for your child and still maintain SSI. So SSI is something you can apply for after you're 18. Another thing that's nice about SSI is it usually comes with Medicaid for your health. So while your child, you don't have to apply right away when they're 18, but a lot of my clients, when the children get close to 26, that's for as long as they can stay on your health insurance. Once they turn 26, your kids have to get their own health insurance, or they could be on Medicaid through the exchange. But if they have SSI, they will automatically also get Medicaid, which is another nice benefit. So $2,000, that's all they can have for SSI. So what does the child do if they are making money? Let's say they're making money at the grocery store, or they are getting their SSI. What are they going to do with it? If they're not really spending it and it accumulates very quickly, they're going to be over the 2,000 resource limit and have an issue. So one great option is an ABLE account. So an ABLE account is a type of bank account that your child can open after they're an adult, and they can put up to every year. Right now it's $16,000 maximum. It goes up a little bit every year. They can put that in the account, and whatever money is in that account will not hurt their Medicaid or their SSI. It doesn't count towards their $2,000 limit. So it's a great option. The downside with the ABLE account is, again, you can only put $16,000 in it, and the total amount you can put in is $100,000. So you don't want to overfund it. The other big problem is long time, once your child's lived their life, when they pass away, if they have any money in the ABLE account, has to pay back Medicaid or any government benefits they got. So that money is going to be lost. So we don't want to overfund an ABLE account, but for the money that the child is making, either from SSI or their job, ABLE account works very well. They can also use the money in the ABLE account for most, it's supposed to be qualified disability expenses, but it's very broadly defined. You can pay for things for food, for education, for training, for housing. So ABLE account is really a great way to go. So what's another way to protect assets for your child? So mostly what I've spoken about so far is really your child's planning. Becoming their guardian is something, or having them create proper documents like powers of attorney and healthcare documents, also applying for SSI and maybe starting an ABLE account, which you can do online. By the way, you don't even have to go into a bank, and there's lots of different options for different ABLE accounts. But what about your planning as the parent? What can you do? So one of the most important things in a parent's planning, or any family member that has special needs loved ones, is a special needs trust. This is a great tool I use for so many families. Any amount of money can be left in a special needs trust for your child, and it will never interfere with their benefits. Even if they inherit $1 million life insurance policy that goes in their special needs trust, they can still keep their SSI and they can keep their Medicaid. And that's because a special needs trust is considered a supplemental trust, meaning it supplements your child's life, doesn't take the place of the benefits. Can be used for a whole host of things, for their hobbies, vacation, any type of thing that they need. And it's really great because years ago, when we had special needs families, we had to disinherit the special needs child, because if they got any money in their name, they would lose all of their benefits. So now we have this great trust option. I use it all the time. It's great for so many things. And you can pick any trustee that you want. It can be a family member. The family member can be the trustee with a corporate trustee who maybe has experience in this. And all of the money in there can benefit your child. And then you can also say, if there is money left in that trust, unlike the ABLE account, if there's money left in that trust, you can say whatever you want where it's going to go. It can go to your other kids. It could go to a charity. It could go to a loved one, whoever you want. So it works really well to protect assets so your child can have the best life possible and also maintain their government benefits. A really interesting way to use a special needs trust is to make it a separate standalone. I call it a standalone special needs trust. So as a parent, you'll have a will, you'll have a trust, but outside of that, you can have a totally separate special needs trust. Why is that good? That's great because any family members can leave assets to that special needs trust. So if grandma wants to include the grandson, you give her the name of the special needs trust. She can leave anything in her will to that trust. If she has a retirement account, she wants to name your special needs son as the beneficiary. Instead, she names the trust. It works great. All family members can contribute. All benefits are maintained, and it provides a much better life for your special needs child. Really good way to fund a special needs trust is with life insurance. So this means while you're alive, you don't have to put any money in the trust. You know, everyone has, we live in a very expensive area. We all have a lot of expenses. People get very nervous when I start talking about trust. Oh my God, how am I going to fund this? What am I going to put in there? You don't have to put anything in there while you're living. And when you pass away, you can name anything in there to go through the trust for your child. A really nice thing is life insurance. Life insurance works very well because usually you can get it pretty inexpensively, and then you can name the trust as the beneficiary. You can also name your other kids as the beneficiary. Maybe you only name a certain percentage of the life insurance for your special needs trust, but life insurance works really well with a special needs trust. The other thing that's great for a special needs trust, and really better now under the new law, is retirement accounts. So retirement accounts, a lot of my clients, their biggest asset is their home and their retirement accounts. Retirement accounts are very popular. And retirement accounts, as you may know, when you put away money in your retirement account, there's no tax, right? When does tax hit the retirement account? When people take money out of a retirement account. That is the same thing when you inherit. So when I pass away, my son Henry inherits my retirement account. He will get his own inherited retirement account from mine, and then he's going to take distributions from it. And that's when the tax hits. When anyone takes distributions, that's tax. Now, it used to be that when we inherited a retirement account, we could stretch out the distributions for our lifetime, which was very handy because if I'm in my prime earning years and I inherit a retirement account, I don't maybe want a lot of taxable income then because I'm going to have to give half of it away to the government. It might be better to stretch it out later in life when I'm retired or when I am not making so much income. But they just changed the law. Maybe not just, but recently they changed the law. And that's something known as the Secure Act. And what the Secure Act does, spouses can still stretch it out, but pretty much anyone else who inherits a retirement account has to take it out in 10 years. That can be really very tax terrible. I mean, it could be half the money that you think you're leaving your kid could wind up going back to taxes if they happen to inherit at their prime earning years. But one exception is a disabled child. So in the Special Needs Trust now, we have new language to deal with this new Secure Act, and basically if a retirement account goes through a special needs trust. Now, regulations are still coming out because we know how the government is. They're very slow. And sometimes they write a law and they don't really figure out all the details till later on. That's something that's interesting how it works. But in any event, it looks like a special needs trust for a disabled individual, the trustee of that trust could stretch it out for their whole life. The retirement account going to the special needs trust. So if you have multiple kids and one is special needs, it might be more beneficial than ever to have the majority of the retirement account going to the special needs trust and maybe having other assets going to the other kids. So just another way you can use a special needs trust and there's a real tax advantage. Picking trustees can be hard because remember, these special needs trusts, really, they're gonna come into being when you're gone, when both parents are gone. So who's gonna be the trustee? Family members, as I said, it can be a corporate trustee, and I always really force people to pick a backup trustee as well because life is long, you never know what's going to happen. You want to have a plan A, a plan B, and a plan C. So it's really important to talk through with your family members. You could have co-trustees. Maybe you want your other kids involved, maybe you don't. We talk all that through, and we always come up with a really good solution. And the great thing, I think I said this, but it's worth repeating, that special needs trust that you have created in your planning for your child has no payback to Medicaid or Social Security. That means when your special needs child, long time from now, passes, all that money can go to their kids if they have kids, can go to your other siblings. It doesn't have to go back to the government, which is a huge, huge benefit. Another thing that I like to work on with my families, we have the special needs trust, also obviously wills, powers of attorney for the parents, and something else that my families really like is a letter of intent. So that's not a legal document. The special needs trust, that's really legal. It talks about all the legal things we want to protect for your child and things we want to be able to do for your child. Letter of intent is really about the heart and soul of your child. And it's kind of a letter. I don't write it. It's not legal. The parents write it, and it's really their wishes for what they want for their child. For example, my child loves music. That's the most important thing to him. I want to make sure his life is filled with lots of music. I want him to go to live concerts, whatever it is. All those type of things can go in a letter of intent. And I like to keep that with the special needs trust and all the other documents about the family. It's very helpful for the next generation, the trustees and the guardians. So that was the Reader's Digest version of just the main kind of concepts you should think about for your child's planning and for your planning when you're dealing with special needs. And I can say that because I worked at Reader's Digest for years, so I'm allowed to say that. But normally I like a lot of back and forth with people, so I did want to put in some frequently asked questions as well and answer them because a lot of these come up. This one is a big one. Can't I just leave my assets to my other kids? To my other kids, they will definitely take care of Henry. I know them, they're great kids, they will absolutely do that. And that could be, that could be that they are great kids and they will do that. But what if something happens to one of your kids? What if they get divorced? What if they have creditor issues? What if they have bankruptcy? What if, God forbid, they pass away? So much safer to put it in a special needs trust. Like I said, years ago, we didn't have that option, but now we do. It's just much safer. It also lays out a framework and a guide for your trustee of what to spend the money on for your child and what to look. So you definitely don't want to just leave it to other people and say, here's a pot of money for you to take care of my son, Henry. That said, in the special needs trust that I do, there are provisions that say, you know what? Maybe he doesn't need the special needs trust anymore. Maybe he's been working for 2 years and he's totally independent now. There are provisions in the trust that can push a lot of money out to your child. So there are options. It's flexible in the trust. But you definitely don't want to leave your money to your kids and just say, I know they'll take care of them. And we talked about this. What if I don't have a lot of assets? What am I going to do? Do I still need to do this planning? I think it's more important. The less assets you have, the more important it is to protect them and make sure they're there for your family. And as I said, life insurance is a very inexpensive way to ultimately fund a special needs trust to take care of your children. What if a family member leaves something to my child in his name, and they didn't tell me about it, and they didn't put it in a special needs trust, and they just leave money? And I get this call a lot. Oh my gosh, Aunt Phyllis just died. We're totally surprised. She left $500,000 for William, and William is on SSI, and he's going to lose his SSI. What are we going to do? There are still options even at that point. At that point, I can still do a special needs trust, but it's a little different. Now it's William's special needs trust. It's not Aunt Phyllis's, because Aunt Phyllis didn't do the planning to set it up, and you didn't tell her that you had a standalone special needs trust that she could use. So the money's trying to get to William. So William himself can create a special needs trust as long as he's under 65. We can put the $500,000 in there. He can maintain his benefits, but, and this is a big but, any money that's left in that trust when he ultimately dies has to go back to Medicaid. It's another Medicaid payback, just like the ABLE account. That's because the rationale is it's his money. It's not someone else's money. It's his own money now. So he can put it in a trust to maintain his benefits, but he can't have his cake and eat it too. At the end of the day, it has to go back. But there are things we can still do. Another question I get a lot is, what if we're a guardian and then down the road, he doesn't need a guardian anymore? You can petition the court later to remove the guardianship, and they will do that if they think it's appropriate. I will say in all my years of practice that doesn't happen very often, but it definitely is an option. And also, you can get the guardianship at any time. So if you don't get a guardianship, I tell people start at 17, but if your child is 27 and you never even knew you had to become a guardian or do this, and now you're hearing about it, you can still do it at a later date as well. What if a special needs trust is set up and he ends up not needing it? So as I said earlier, you can certainly have terms in your trust like I do, which allow for flexibility, money going out if they don't need it, different guidelines if they have worked for a certain amount of time. I also have language in my trust that says if they don't have any need for it at all, the money can all be distributed to them or to other children. So there's a lot of flexibility in building the special needs trust and the plan. So I know this is a ton of information, and I just really touched on little concepts, but I think the most important thing to know is it's wonderful. We have so many options and ways we can protect our special needs kids. We can get them benefits. We can also not cut anything out from our other kids. Everyone can be involved. Everyone can benefit. And it really is tons of options that we have in New York. And I would just say, it doesn't have to be me, but make sure you talk to someone who kind of knows the landscape and can give you an idea and can help you and navigate you through the path. Thank you so much for having me today. My contact information is Lauren Eisen, Rogers, Habus, and Eisen PC. My law firm is in Orangeburg, and I can be reached at 845-359-5400. I have a wonderful staff, and I should tell you that I always do a free 30-minute phone call, but this stuff is complicated, so if I need to talk 45 minutes or an hour, don't tell anyone. I do that for free as well. Looking forward to helping all you guys and your families.